Hi, I'm Danny Jacobs, legal editor of the Daily Record. Today's webinar is Beyond the FLSA Decision, and it takes a look not only at the impact of the November 22nd Texas court decision that blocked new federal overtime rules, but what happens and what doesn't happen next. We'll also discuss some of the related issues that employers and employees should be aware of, which might be greatly affected by the incoming administration of President-elect Donald Trump. Before we begin, some housekeeping. If you're registered for the webinar and are listening in, you are muted, so we cannot hear you. But you can ask a question for our panelists by typing it into the Ask Question/chat window on the webinar's control panel. We will try to get to as many questions as we can. If you're not seeing a control panel, click on the orange arrow in the upper right-hand corner of your webinar screen. Now let's introduce our panel. Harriet Cooperman is a partner with Saul Ewing. She focuses her practice on representing management in a wide variety of labor and employment law matters. Harriet has litigated numerous labor and employment cases before courts and administrative agencies around the United States. She is vice chair of the Maryland State Higher Education Labor Relations Board and has been an adjunct professor of law at the University of Baltimore School of Law. Harriet, welcome. Melissa Calhoun-Jones is chair of Tidings and Rosenberg's Employment and Labor Law Group. She counsels small and medium-sized companies on labor, employment, and immigration matters. Melissa has represented clients before both federal and state administrative agencies. She previously was a labor relations attorney for the District of Columbia Office of Labor Relations and Collective Bargaining and in private practice in San Francisco. Welcome, Melissa. Greg Greenberg is a partner with Zippen, Amster & Greenberg. He represents employees and counsels small businesses in workplace disputes relating to employee compensation. Much of his practice is litigating claims that deal with classification of an employee or independent contractor or questions concerning overtime pay exemptions or exceptions. Greg has litigated several hundred federal and state employment law claims. Great to have you here, Greg. Harriet, I want to start with you and look at the court ruling, which is why we're having this webinar today. Can you talk a little bit about the ruling, what the judge did in his ruling, and what has happened since that ruling back in November?
Sure. And let me look back up a little just to sort of lay the groundwork. First,
sure.
The Federal Wage and Hour Law, the FLSA, provides that employees employed in a bona fide executive, administrative, or professional capacity are exempt from the overtime requirements of the Wage and Hour Law. And the law further provides that it's up to the Secretary of Labor to define what is meant by a bona fide executive, administrative, and professional employee. So the Department of Labor over the years has issued regulations defining these three exemptions, these three classifications. And in defining it, they've done a number of things. There are basically three requirements under the DOL's regulations that need to be met. That is that an employee needs to meet the duties requirement of one of those three classifications, executive, professional, or administrative. Second, that the employee is paid on a salary basis. And third, that the employee is paid at least a minimum salary level. And the new regulations that were to go into effect on December 1, what they did was they increased the minimum salary level from $455 a week to $913 a week, and also provided for an automatic increase in that minimum salary level every 3 years beginning in 2020. So this regulation was challenged in the U.S. District Court for one of the districts in Texas, and the judge first heard a motion for a preliminary injunction because the regulation was to go into effect December 1. The judge issued that preliminary injunction, which holds in abeyance the enforceability or the enactment of that regulation. And what the judge, it's a preliminary injunction, which means that it's really just in effect until the full case can be heard in full. So in issuing the preliminary injunction, one of the requirements that the judge has to find is met is that there's a likelihood of success on the merits of the case that were brought by the plaintiffs that the regulation was unenforceable. And that's what the judge found. The judge found that while the statute doesn't define what is meant by executive, administrative, or professional, and that, as I explained, it defers to the Secretary of Labor to define the components of that exemption. It held that the Department of Labor exceeded its authority by including a minimum salary level as part of the requirements. The judge said that the statute is clear that Congress intended, when they said executive, administrative, or professional employee, Congress intended that to mean duties of executive, administrative, and professional, and it wasn't up for the Department of Labor to put a minimum salary level. The judge went on to hold that because it was finding that that minimum salary level requirement was an abuse of the administrative discretion and exceeded their authority, that it also, the automatic kicker for the every 3 years also would not go into effect, which is logical. And the judge said that this preliminary injunction would have a nationwide scope. Federal judges do have nationwide jurisdiction. There's a summary judgment motion to decide this case in full, to issue a final judgment in this case that's pending before the federal district court, and the district judge may hear that according to the judge's schedule. Now, last week, the Department of Labor, as expected, appealed the judge's preliminary injunction to the Fifth Circuit Court of Appeals. And the Department of Labor also asked the Court of Appeals to hear this appeal on the preliminary injunction on an expedited basis. It's interesting, though, because the schedule that the Department of Labor proposed to the Fifth Circuit has the briefing of the appeal going into February of 2017, and then the court will hear the case as proposed by the Department of Labor sometime thereafter, and that's their expedited schedule. The reason why I say that's interesting is because the new administration will, President-elect Donald Trump will be sworn in as president on January 20th, and we'll have presumably a new Secretary of Labor, and there may be a new determination made at that point as to whether the new administration wants to pursue this appeal. So that's where we currently stand.
Has Trump or his administration said anything yet about the judge's ruling, or have they not said anything?
No, they haven't said anything, and he's raised concerns about the new regulation, but hasn't been clear in terms of what his issues are with the new regulation.
So, Melissa, where has the judge's injunction left employers, many of whom were preparing months in advance for this December 1st changeover?
Right. So as soon as these regulations were finalized in the early summer, employers started preparing for the potential reclassification of employees as of December 1, and some employers had already gone ahead and made changes, but others were waiting until December 1st. And employers were taking this opportunity to not only prepare for the reclassification of people who fell under the new $47,476 threshold, but also to look at the classification of employees overall. There's some idea that the Department of Labor might increase audit efforts or be taking a close look at whether employers had people properly classified, and that jobs change over time, and that this is an opportunity for employers to make some corrections, salary threshold notwithstanding, if they found that they had misclassified people, and to tie that all into this December 1st transition date. And what's happened is that I've spoken with lots of different employers in Maryland who did in fact find that they had a few people that might have ended up classified in a way that they probably shouldn't have been classified, and that they were planning to reclassify all those people as of December 1 along with the same pot. And so what's happened is that for people in that situation, they are now facing the fact that they know that certain of their employees are misclassified under the job duties test that Harriet referred to, and are preparing to reclassify them going forward. That's a delicate move, but now that they have knowledge that that people are probably not classified properly, they're undertaking that. I think the more difficult scenario is for the people who have already reclassified or bumped. One of the options was to reclassify everyone under 47,000 who otherwise perform the job duties of an exempt person, and make them non-exempt. Another option would have been, and this was feasible primarily for people who are close to the 47,000 level, would be to bump them above it, so that if they qualified in all other respects, they would then be above the salary threshold, so they could be classified as well. For employers who have already implemented those changes and given people increases, they otherwise wouldn't have had to do that. So I think that's, I don't know, I think we're going to talk about that a little later, but that obviously creates some interest. But then the other thing is just trying to get your hands around, will this ever take effect? Do we need to continue down the path that we're on? And what about the communications that we've already issued to employees, and how do we communicate or correct those communications, or let employees know that changes may happen in the future, but not right now?
You work with employers in a variety of sectors, life sciences, hospitality. Has there been different reactions depending on the sector that you work with to what's happened, or is it pretty uniform across all employers?
For me, it's been uniform across all employers. I think it'd be interesting to hear if other people have different experiences, but I've had employers in many different sectors contact me about the need to take a further look at their classifications.
So
yeah,
Greg,
I mean,
go ahead, Harriet.
No, I was just going to say my experience, employers, across, the wide range of industries have been concerned and have to reclassify, or at least look at their employees. However, there are some industry segments where it tends to impact a little more so than others, and those are areas such as hospitality, and nonprofits, higher ed. We have big fluctuation of hours, particularly seasonal, and in the healthcare industries. That's where we've seen a really huge impact.
So Greg, the other part of this equation, of course, is the employees. And if I'm an employee who initially had been reclassified as a non-exempt worker under the proposed regulations, that would make me eligible for overtime. And now, if the judge's ruling company says, never mind, does an employee have any recourse? What can they do in response to this?
Sure. So, as you'd imagine, for the past couple months, folks have been calling my office and saying, hey, I've got this thing that my employer wants me to sign and says, we're reclassifying your job, and, this is your new job description, and by the way, we're giving you a raise, and now you're not owed overtime, or maybe now we're going to pay you overtime. And they say, well, nothing's really changed except this piece of paper. Uh, and they come in and they say they want to pay me $500, but looking for the inconvenience. But looking back, I've been working a lot of overtime. So what's been happening, I think, for the employees is they've kind of been self-educating. They've been going online and talking to attorneys and talking to friends and figuring out, well, what's been going on for the past 3 years? Have I been owed overtime? And that's a very popular thing right now. The prior speakers have said that it's a very delicate dance for an employer right now. Well, what do? You got to tell these folks that now we're going to pay you overtime. And by the way, in my investigation, I've determined that I might have exposure to you and to similarly situated individuals for overtime going back a couple of years. So if you are an employer right now and you've been told, well, now you're going to get overtime, or now we're going to give you a raise, so you're going to be continue to be exempt, I think what you need to do is you need to take a long look at what your actual job duties are, not necessarily what your title is, manager, sous chef, assistant manager, whatever they're going to call you, but are my job duties exempt? Because whether this regulation goes into place, whether the 455 becomes 913 now or in the future or never, you might be owed overtime. So it's worth an evaluation. Plus, what was talked about before with regard to this exemption, this is an exemption if this were taken to court. These white collar exemptions are the obligation of the employer to prove. So if it's even a close call, it's worth an employee looking into it, because the employee doesn't have to prove that he's or she is owed overtime, but rather it's going to be the duty, the burden of the employer to show by a high level of evidence that the person is in fact exempt. So yeah, I mean, if an employer's told you one thing then changed their mind or given you a couple stories, then the thing for the employee to do is to go and talk to an attorney that understands this area of practice and investigate the actual job duties. And that includes if an employer told employee they're getting a raise and then rescinds the raise. That's something that can be investigated by an employee lawyer. Well, of course it is, and I think it goes to where there's smoke, there's fire. Why are they adjusting my pay? Why are they changing my title? Why are they saying I was owed the money or wasn't owed the money? It's these types of irregularities, weirdness at work that brings an employee to an employment attorney that says, can you look into this, because I don't trust what's going on at work. So yeah, that's what's going to trigger an investigation by an attorney or the Department of Labor. I wanted to dive into the classification issue a little bit more, but a reminder to anyone listening, if you want to ask a question, feel free to submit them, and I'll be able to ask our panelists. But on the classification issue, Harriet, can you explain a little bit how the process works for classification?
Sure. So as I explained, to be an exempt employee, the employee must perform a primary duty of either an executive, administrative, or professional classification, and as well be paid on a salary basis and a minimum salary level. So you have to meet all of those requirements. But the first thing is the job duties test, and that's critical. And in terms of job duties, we talk about primary duties. The primary duties is defined as for all the classifications as the principal, main, major, or most important duty that the employees perform. And so we said there's 3 different kinds of classification: executive, professional, and administrative. To be an executive employee, there's specific job duties that the employee has to perform. Those are, number 1, the employee must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise, the business. Second, the employee has to direct the work of at least 2 or more other full-time employees or full-time equivalents. And third, that the employee has to have authority to hire, fire, or to what we say effectively recommend hiring, firing, promotion, and the like of its subordinate employees. So that's for the executive. For the professional employees, there's actually 2 kinds of professional employees. You have the learned professional, and that primary duty of work requires knowledge of an advanced type in a field of science or learning customarily acquired by a prolonged course of specialized educational instruction. Lawyer, doctor, certified public accountant, registered nurse. That's a learned professional, and you have to actually apply that knowledge to your job. Then you have a creative professional, and that requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. An executive chef, a fashion designer, something like that. Then you have the administrative employee, and this is the most difficult, I think, that people have problems with. The primary duty is the performance of office and non-manual labor related to the management or operation of the business, such as running the business behind the scenes. And the primary duty includes the exercise of discretion and independent judgment with respect to matters of significance to the business. And that's where there's really real difficult that people have. What do we mean by discretion and independent judgment? And here we're talking about people that really exercise substantial discretion without supervision, without someone sort of standing over their shoulder. They're not following any kind of a guidebook that says you have to do this, 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 and this. They're actually making some significant discretionary decisions. So those are the classifications, and Greg was right where he said you have to look at what is the employee actually doing, not just what a job description says, but what is the employee doing in performing their job, what's required, and how does the employee exercise those job duties. And so that's critical that employers do that with respect to all of the positions to make sure that the employees are properly classified. And if those employees are performing those job duties, those primary job duties, then you have to look at, are we paying them on a salary basis, which means that the employee receives a guaranteed salary each week that does not fluctuate with the number of hours that the employee works. So if an employee works a half a day in 1 week, the employee has to be paid the full salary for that week. There are certain exceptions, but that's basically the rule. That's meant by a salary basis. And then, of course, is the minimum salary level, which is what the new regs go to. And at least right now, until that's fully overturned, then the employee has to make at least the minimum salary level. So if you have an employee, just to go back to the question that Greg addressed, if you have an employee that truly fits within the classification, the executive, administrative, or professional, and that employee was given a raise or told that he or she was going to get a raise with the new regulations going into effect, to keep that exemption, then if an employer changes its mind and says, well, we're going to hold off because the regulations aren't in effect, that may not go over too well with the employee, but there wouldn't be any liability imposed on the employer at this time because the regulations haven't gone into effect and the other employee otherwise meets all the requirements, at least that are currently in effect, for that exemption.
So, Melissa, you mentioned before that some of your clients and some employers have just gone forward with their changes despite the judge's ruling, and it sounds like there's a lot of legwork involved in getting these classifications up to date. Will you recommend employers to continue to go through with the process, or should they stop and wait for the judge or for the ruling to be finalized or for a decision to be made?
Well, because there's, excuse me, this kind of a bifurcation of the process, right? Because there was the class of people that Harriet just referred to who are meeting the job duties requirements of the test and currently are being paid on a salary basis and meeting the threshold, but may not have been correctly classified as exempt had the regulations gone into effect simply because they didn't make $913 a week. Those people are sort of out of the equation now, because we're not talking about reclassifying just based on the salary threshold. But if in the course of the process employers have uncovered that people were classified as exempt who are not meeting the requirements of the job duties test or salary basis test, then those employers the people I've talked to are continuing with their process, because they, regardless of the salary threshold, they have the obligation to comply with the law, and are continuing down that process, down that road, because of their sense of need to classify people properly to avoid liability in the future, or continuing to create the risk of liability through misclassification. One thing, forgive me for the frog. One of the things I wanted to add to what Harriet was saying as well is it's been very interesting for me in the last several months talking to employers about their classification of employees and where they put them, right, when they classify them as exempt. And I agree that the administrative exemption is the most difficult one to assess and to apply. It also happens to be the place, at least in my experience, where most of the employers lump their employees, and they sort of automatically assume that anyone who isn't on the production end of the business is administrative from an exempt perspective, and that's led to some pretty interesting conversations about requiring employers to really dig deeply into what the employees actually do, what level of decision-making authority do they have, when they are engaging in their job responsibilities, how closely are they supervised, and things like that, just to try to peel back that onion and find out that at the core, are they really operating at the level of an exempt administrative employee. And the other thing that I've found myself talking to employers about a lot, and I just want to throw this out there because it's a consideration for classification, is that employees need to qualify for one of the exempt classifications, not all of them, but at least one in order to be qualified as exempt and are classified as exempt, and that it's important for employers to try on the different hats, right? So you may have director of IT, but who only has one subordinate, wouldn't qualify as an exempt executive, but could be likely that he or she is going to qualify as an exempt administrator by virtue of the duties performed as a director of IT. So I encourage my employers to not make assumptions about where someone will fit in, but to try on all the different hats to see if there's one that truthfully fits with the employee, and to continue through that process. But as you pointed out, that's a pretty long slog to go through that. But I think that most of the people that I've talked to, or all of the employers that I've talked to, are interested in doing it right. So they're taking this opportunity to continue.
So Greg, Melissa said she's a lot of people put in the administrative pot. Have you noticed trends in how employers are classifying the workers in the years leading up to this proposed FLSA change?
Well, look, a lot of employers still believe that if you pay anyone's salary, they're not going to be out overtime. So whether the employer is actually sensitive to, I believe this exemption applies, I think we're probably overthinking it. If an employer calls someone a manager or the office manager or administrator and pays them a salary, generally that's what just the employer is going to do, and it's because they maybe talked to a friend or a colleague or another business or their CPA, but it's generally because they didn't speak to an attorney that focused on employment management side, labor, wage and hour issues. So that's what I see. I see employers that will pay just a day rate or pay a flat salary rate and say, well, I don't pay overtime because I pay you a salary or I pay you a day rate. you also see a lot of employers try to get around the overtime law by saying, well, you're not actually an employee. We're going to call you an independent contractor, and we're not going to pay overtime because the Maryland and federal overtime laws don't apply to independent contractors. That's what I see a lot of. I see a lot of employers kind of taking an ill-advised move, thinking that they're smarter than the system, and it's only going to get them in trouble when an employee finally goes to an attorney and say, I'm not really an independent contractor, or I'm not really a manager. I'm just another office employee, or I'm not really the administrator of the office. I don't control anything. I just do whatever my boss tells me to do. That's what I see employers doing.
You mentioned Maryland law. Is there any overlap between what's happening at the federal level and what the existing state law is regarding wages?
With regard to overtime?
Yeah.
It's my understanding that the Maryland overtime law would mirror the requirement of the FLSA with regard to the white collar exemptions.
Mm-hmm. Yeah, the Maryland overtime law actually adopts the federal exemption.
Okay.
Reference. Yeah.
Well, I'm going to move on to another couple of areas of employment law. But again, if you have any questions about FLSA or anything else we're talking about, please feel free to chime in. I wanted to talk about on July 1st, there's a new OSHA rule that kicks in that will require certain employers to report injury and illness information to OSHA, which will then post this information online for public viewing. I want to ask Greg first, do you think this will survive the Trump administration's review?
It's hard for me to know what will or will not happen, and with our new president-elect. What I think, I do mostly plaintiff side work, and I think that my clients or potential clients would be happy that regulations are going to effect that would be geared at making sure they have a safer workplace. I represent a lot of construction employees, a lot of restaurant employees, and at least for the employers large enough that this would apply to, this would be good. It certainly would put a new burden on an employer, making it harder to run a business, and I don't know that burdensome regulations or apparent burdensome regulations are going to survive in the new administration. So I can't guess, but I'm not optimistic.
Harriet or Melissa, any thoughts about the OSHA rule?
No, not on the OSHA.
No. We have a question. We have a question from a listener, and it is, how do the new Department of Labor regulations affect the job duty analysis with regard to the executive, professional, and administrative classifications?
They don't.
They don't.
That's correct.
All right. Easy enough. Let's move on to the National Labor Relations Board. Are we likely to see any change in philosophy from how the NLRB has proceeded in recent years? So, Harriet, if you want to start, any thoughts on that?
Sure. Well, yeah, I think we're going to see a significant change from out of the NLRB, and it's interesting to note that right now the NLRB is a 5-member board. Currently, there are 2 vacancies. And one of the members goes off the board in the fall, as well as the general counsel goes off the board towards the end of next year. So there's a number of things that can happen. What I expect is that that Trump is going to fill the board with fill those 2 vacancies, and that will well, depending on who he puts in, my expectation is that he will put on 2 very employer-friendly members, which would then be there would be 3 members of the board that tend to be employer-friendly. The Obama board has been extremely aggressive, and in fact has overturned decades of established board precedent. A big action of the Obama board has to extend its jurisdiction beyond what it ever has been seen since the act was enacted in 1935 to regulate non-union workplaces in areas well beyond what was typically viewed as protected concerted activity, which is what the law protects. So I expect there to be a rolling back. Some of the areas that I expect to see a rolling back. First, the Obama board has substantially regulated employer policies and practices. It has held, for example, that an employer can't have like an established rule that every time it conducts an internal investigation, employees have to keep, if they're questioned during the investigation, they have to keep that investigation and the questioning confidential. It has also stepped on, the extent of confidentiality rules that an employer can have. It's had a big impact on internet uses, social media policies, employer discipline. It has severely limited employers' efforts to regulate its workplace from offensive speech, insubordinate behavior. And I expect there's going to be a new look at that. The issue of arbitration agreements for non-unionized employees and whether they can waive collective actions. The board has said that you can't require non-unionized employees to sign an arbitration agreement that waives their right to have a class or a collective action. And actually that may end up that there's a dispute among the circuit courts in reviewing the NLRB's decisions, but that may go up to the Supreme Court, but I think the NLRB is going to take a different approach to that. Union organizing. The NLRB has issued rules that require very fast elections. Within 21 days, they can be from when the union files a petition to represent employees to the conducting of an election, which is much faster than was ever in the past. We may see a change there. Also, the NLRB has allowed what's known as mini bargaining units. The famous case where the board found that a bargaining unit of just the shoe department of a Macy's store is a sufficient bargaining unit. I think we'll see a change there. Another area that's gotten a lot of publicity is the area in higher ed. The board, again, overturned a well-established rule and found that graduate students actually can constitute employees under the National Labor Relations Act and form and join unions and require the college or university to bargain with the union. And also another huge issue is the issue of the joint employer in franchises. So, would a franchisor like McDonald's be considered a joint employer of employees of an individual franchisee's, one McDonald's restaurant? So these are all really significant issues, and I think that a new Trump board is going to revisit those issues.
Melissa, your thoughts on that? Do you think we'll see some changes in the NLRB in the Trump administration?
I do. And as a management attorney, I welcome some changes. The last couple of years have been really harsh on employers in terms of the ability to do business and the ability to maintain a workforce that's productive and things like that. Employee protections, of course, are required, but the NLRB has really, in the last several years, widely expanded its scope and in ways that really hamstring the employer to say, listen, you either risk an unfair labor practice or you just ignore, right, this conduct. The one other area which is interesting right now with the National Labor Relations Board is the misclassification issue of employees as independent contractors. That, of course, is a huge federal initiative and spearheaded by the Department of Labor, and its advice that came out in 2015, and National Labor Relations Board has just recently issued an advice memo where it comes very close to stating that misclassification of employees as independent contractors is an unfair labor practice, but it doesn't actually cross that line. You still have to have another kind of a violation, but you can see the trend in the National Labor Relations Board is to find sort of per se violations of policies in and of themselves being violations rather than requiring some action by the employer that truly infringes on employee rights. And so I imagine that with the existing vacancies and the two new vacancies coming up in the fall, that some replacements will be put in. But it'll be interesting to see over time, how far back that comes. I think that Harriet alluded to the franchise ruling, and I think that really shocked everybody when the National Labor Relations Board suggested or ruled that McDonald's would be liable for the actions of its the franchise owners, and it'll be I would welcome some additional movement on that, because that creates some pressure, right? That goes far beyond the actual ins and outs of the daily operations.
So, Greg, should employees be concerned about the NLRB under this incoming administration?
Well, first, I've had a different perspective on the past couple of years with the rulings, especially as it relates back to the Fair Labor Standards Act. These Fair Labor Standards Act overtime claims typically, or not typically, but ideally would proceed as what's called a collective action, giving individuals rights to proceed as a group, an opt-in group. And these rulings from the NLRB have been making some headway in getting rid of these arbitration agreements that would waive an employee's right to prosecute collectively a Fair Labor Standards Act claim. So again, that is in the circuits right now with a split. I think it's up for in the Fourth Circuit. I think it's up for oral argument very soon, or maybe it just was argued. I don't know exactly. But as well as the franchise decision, expanding the definition of employer to a vertical joint employer, the franchisor might be joint severally liable. I was liking the progress we were making. Maybe I have a different opinion on that, but I don't anticipate that with new appointees to that board, we're going to continue to make the same progress. And I would imagine that some decisions are probably going to go the opposite way. Maybe taking back the progress for the NLRB, and as well as statutes like the FLSA, which kind of rely on more progressive opinions to buttress more progressive arguments that I might make on behalf of an employee.
Both Greg and Harriet mentioned split circuits, and that leads us to the last thing we'll cover here is the Supreme Court. And before we get there, again, if you have any questions to ask before we wrap up, feel free to submit those. But obviously, President-elect Trump will have a chance to appoint at least one Supreme Court justice and possibly one or two more than that. Some have suggested the High Court will have a chance to soon make important rulings on issues such as we talked about arbitration provisions, class action litigation, union agency shop fees, administrative agency powers. Harriet, can you discuss sort of an overview of the issues related to employment and labor law you think are in play at the Supreme Court coming up?
Right. Well, actually, so obviously changes in the Supreme Court composition could have an impact and a lasting impact, but changes take place over time. And and one thing that we've learned from Supreme Court history is that you really can't predict how somebody's going to rule once they become Supreme Court justice or on a particular issue. So, right now there's one vacancy, and the Supreme Court has been in rather bit of a hold pattern on deciding a number of cases because of the eight-member court. So currently, though, there's only one labor case, and it's a little bit of an esoteric case, but there's only one labor case pending at the court. They've denied cert on a whole load of cases. And the one case that's pending is called NLRB versus SW General. And that actually concerns the general counsel of the NLRB, the former general counsel, I should say, Leif Solomon, who was nominated by President Obama to be the general counsel, but while his nomination was pending, he was appointed as the acting general counsel. And so there was a challenge to his acting as general counsel, because under Article 2 of the U.S. Constitution, when a person's up for appointment to a position, they can't act in that position. And the lower court upheld that challenge, so that's pending before the Supreme Court. The implications, if the court affirms the lower court's decision and says that Solomon was improperly acting as the general counsel, the implications can be possibly significant. A couple of years ago, the Supreme Court ruled in the Noel Canning case that the NLRB acted beyond its authority, or they ruled on cases when they didn't have a three-member quorum. There were only two members of the NLRB, and therefore all of those decisions were thrown out, and that's what everyone points to in this case if the general counsel is improperly acting in that position. So it could have some impact. There's a number of cases that are that are still pending cert petitions. The one that we mentioned were the whether employees can waive their right to bring a collective or class action in an arbitration agreement, whether that violates their rights under the National Labor Relations Act to engage in protected concerted activity, two or more employees joining together to challenge an action of their employer, which is what's argued a collective action is a form of protected concerted activity. So the NLRB has said you can't have a waiver of collective action. The Fifth Circuit reversed the NLRB there. The Ninth Circuit and one other circuit upheld, I think Seventh, upheld the NLRB. And so that's those cases the Supreme Court very well may take up this term. There's other issues that are out there that we may hear more about. The whole area of transgender rights, which that spills over into the workplace, and the EEOC's been pretty aggressive in extending what does discrimination on the basis of sex mean under Title VII. So we very well may see cases on that issue before the Supreme Court, and that's an issue that the appointees by Trump may have not as progressive views as some other justices. So we may see some interesting decisions out of the courts in those areas.
Melissa, has the transgender issue come up with any of your clients, and how to deal with that and what the EEOC has said?
Well, it's actually come up in the hospitality industry, not from an employer perspective as much as restroom access for clientele. Mm-hmm. And from a Maryland law perspective, of course, gender identity has been protected for a long time. And OSHA has recently issued guidance for employers regarding the connection between restroom access and the duty to provide a safe workplace. And so when I've talked to employers about about that issue in particular. Some of them have had the ability to, sort of relabel their single user restrooms and make it clear that employees have, or patrons or employees have the right to choose to use, to not use, to use the restroom of their choice, and have followed that rule of thumb. The other issue, of course, with transgender employees is dignity and respect, and figuring out how to navigate the change in name and pronouns and things, and working relationships and things like that. I haven't yet had a client call me and talk to me about an employee making the change, right? So for the most part, we're talking about someday in the future and how to respond to those kinds of changes in the workforce. But it's definitely something that is on the forefront, and I'm sure many employers are addressing it. And the majority of the counties, I think, that have civil rights laws also protect on the basis of gender identity and gender expression. So it's something that Maryland, in many of its counties, is preparing for, and by these progressive legislative enactments.
Greg, have you seen any increase or any more transgender employee cases come your way?
Just some folks will call with questions, but I certainly have not been someone who's been filing them or taking them these types of cases to administrative agencies. It's just not a focus of my practice, so I'm not the best person to answer that.
Are there any other labor-related issues that you're keeping an eye out on going forward, either at the state or federal level?
What I am focused on generally is with regard to, I represent a lot of employees that are not paid minimum wage or overtime, and they also happen to not have the proper immigration status to work in the country. Now, they are still entitled to minimum wage and overtime, notwithstanding their immigration status. In fact, that's not even a relevant consideration. What I'm keeping an eye out on is, under the new administration, whether these individuals will still feel comfortable stepping forward, or whether they're going to have to go back into the shadows for fear that if they are to prosecute their claims, they're going to risk some sort of adverse action by the government. So that's what I'm curious happens with regard to immigration policy going forward in the new administration and the workplace rights of first-generation immigrants.
We only have a couple of minutes left. Harriet, go ahead. Oh. Any employer perspective on this?
Well, yeah, I was just gonna throw in, and Melissa's comments made me think of this, and that is what I expect to see. I expect to see with the Trump administration and the Republican-dominated Congress, less or no progressive labor and employment legislation and activity. What I do expect, however, is that the states will respond, and I think we're going to see more activity at the state level in progressive labor and employment legislation. We've been seeing, at least in a number of states over the last few years, a lot of activity. Maryland is one, actually. For many years, Maryland really didn't have many employment laws, but over the last, I'd say, 10 years or so, it's enacted quite a number of progressive employment laws. I think we're going to continue to see that, as well as in some local jurisdictions. Maryland, for example, has a higher minimum wage than the federal law, and will continue. It's built into the statute for the minimum wage to increase. I think it goes up to 2010. I think, but 2010, 2000. It goes up to $10, I think, each year on July 1st of each year. We've seen Maryland has protective legislation for employees in terms of their social media accounts, their ownership and use of social media accounts and the like. And so I think we're going to continue to see this as the federal at the federal level retrenches somewhat.
We are just about out of time for today, so I'll ask one more call for questions while I wrap up everything. I'd like to thank Harriet and Melissa and Greg for their time. We will keep today's session on our website if you want to watch or hear it again. And as a thank you for joining us today, we're offering you a 1-year digital access to the Daily Record for only $99, or $70 off the regular subscription price. You'll find the promo code in the email we sent you prior to the webinar and in a follow-up email you will receive soon. Thanks again to our panelists and all who joined us this afternoon, and have a nice day.
Thank you.
Thank you.
Thank you.